Hello, Mr. Guapo. It's Lisa James. I understand your need and reliance on me to evaluate your website and its terms and conditions. Your question: do you think the agreement is a valid contract? Priceline.com's agreement is a valid contract between you and the consumer. But legally, in the court of law, a valid contract agreement must contain a few elements, and the elements are all offers and acceptance, and intention between the parties to create binding relations, consideration to be paid for promises made, legal capacity of the parties, and legality of the agreement. So agreements that lack one or more of the elements I've listed is not a valid contract. Within the agreement between user and Priceline.com, it's written, Priceline.com reserves the right in its sole discretion to amend, modify, or alter this agreement at any time by posting the amended terms on the site. This statement is known to create illusory, which is misguiding to the visitor and consumer, and if ever sued, can put the company in a position that could possibly remove some very important provisions that are needed in the contract. I'm reminded of a court case, Douglas versus U.S. District Court, Talk America, and the court said parties to the contract have no obligation to check the terms on a periodic basis to learn whether they have been changed by the other side. The courts brought out the point that Douglas would have had to check the contract every day for possible changes without notice, and examination would be fairly cumbersome, as Douglas would have had to compare every word to the posted contract with his existing contract in order to detect whether it had changed. Because consumers usually don't read the full terms and conditions, by having disclaimers, we need to adjust the website to bring clear attention to this call to action for this agreement. Again, consumers don't either fully read it and understand the disclaimers, so it would be wise to maximize their exposure to the seriousness of them by displaying a link at the top of every page. Although unpleasant as it may be, it's for your protection, and in duty of care, having terms and conditions backed with an insurance policy in case someone looks to sue. Because you have other websites backlinked to the Priceline.com, it would be beneficial and a show of duty of care and to place this agreement on each web page. The views expressed are the author's own and do not necessarily represent the views of Priceline.com. This will also help in case the users don't receive what they felt they should have received, leaving Priceline.com free from legal action. Does it matter whether a visitor affirmatively assents through clicking I agree icon or something similar, is your question? Or should a user be bound solely through the use, i.e., even though the user has not read it? I don't believe that it would even matter, although I do believe that it must be visible and accessible on every page to proceed using the website. Some of the user's obligations are found in 1L. Each user using this site for or on behalf of a third party agrees to indemnify and hold each covered party harmless from and against any and all liabilities, losses, damages, suits, and claims, including the cost of defense, relating to the third parties or the user's failure to fulfill any of its obligations and as described above. You are directly responsible for any requests submitted, including for total charges and performance obligations. Priceline.com does have an obligation per agreement in the area Name Your Own Price, Hotel Service Additional Restrictions. We or the applicable hotel may, on an exception basis and at the request of the hotel guests, waive one or more of the restrictions after the hotel room has been booked. We may, in our discretion, impose additional obligations and or fees in connection with any such waiver. No user waiver requests will be accepted or considered prior to or as part of the request. Your question: are there any statements in the agreement that you think are unenforceable? There's one that I'd like to bring up, and that's in 1-P, modification, termination of usage. Priceline.com reserves a right in its sole discretion to modify, suspend, or terminate the site and or any portion thereof, including any service or product available through the site and or your profile, account password, or use of the site, or any portion thereof at any time for any reason, with or without notice to you. In the event of termination, you will still be bound by your obligations under this agreement and any additional terms, including the warranties made by you and by the disclaimers and limitations of liability. Additionally, Priceline.com shall not be liable to you or any third party for any termination of your assets to the site. And I do feel that the company has put that there because Priceline.com is obligated to protect itself no matter the cost. What changes would I recommend? I would recommend revamping the website, adding visible disclaimers linked on the top of every web page, along with a website link, www.tosback.org. This is a site that's recommended, and I recommend this to be linked on the disclaimer page along with the terms and condition as a terms and condition tracker. This will give them a side-by-side before and after comparison, highlighting what has been removed from the policy and what has been added. So I would suggest that Priceline.com also come in agreement with tosback.org, and to be able to have that terms and conditions or terms and services there so they can see all the changes. It will just make it easier for Priceline.com. I hope your questions were answered clearly and given you some understanding concerning Priceline.com's website's needs and your agreement contract, along with terms and conditions. Thank you for allowing me to look into this for you. And if you have any further need of my assistance, please give me a call. Thanks.